Hello, everybody, and welcome again to my live show. We're in October. I can't believe we're on the downward slide to the end of the year. It came so quickly. I'm taking out a few moments today out of my hurricane prep to talk to you to give you a little information about estate planning. And this is the perfect time to talk about it because during a hurricane or a storm or something, we always want to make sure that we have everything in order. This is the time where we go, okay, what if something happens to me? What if something happens to my stuff? What if something happens to a loved one? Do we have everything in order? Do we have everything in order where our family knows what we want done with it? Where is it located? What do we want done? Where do we want it to go? How to access it? All of that kind of stuff. This is a perfect time to talk about it. I know a lot of people have like lock boxes in their houses that are waterproof, fireproof, all of that, and that's great. Just make sure that somebody else has access to it. Anyway, as I said in my video from last week, we're going to talk about estate planning. Perfect time to talk about it. What is estate planning? Estate planning is what am I going to do with my things and stuff? And what am I going to do with me? So today I want to specifically talk about our things and stuff, especially since we're sliding into what Florida and maybe another state might encounter these hurricanes. Just Helena just passed through. Now we're waiting for Milton to pass through. And so what do we want done with our things and stuff? So first off, I want to talk about a will. What is a will? And what I'm saying is WILL, just like the little overlay there for you. Sometimes my Minnesota/Florida accent gets a little confusing, but a will. A will is what is going to happen to all of my things, my bank accounts, my house, my car, my other house. What is going to happen to all of my things and stuff if I pass away? Well, it's not even if I pass away, it's when I pass away. What is going to happen to it? Now, I always get people that come to me and they want to talk about their things and stuff and their will and what they want to do with it. They come to me, they get a consultation, they write a whole bunch of notes and they look like they're really paying attention, and then they go. And then something happens, and then now all their things and stuff are kind of up in the air. Now, here in Florida, remember, I'm a Florida licensed attorney. And so I'm going to talk about Florida law. If you're listening to me from another state, another country, you want to make sure you talk to an attorney in your area about the laws. Here in Florida, if you die without a will, and that's called intestate, INTSTE, then your stuff will go by blood. And I always tell people the blood flows in Florida. So here you are. Let's say my parents live in Florida. This is easier. Mom and dad. Mom and dad have 3 children. So when they die, it goes up. Well, it can't go up because they don't have parents. They're deceased. So it has to flow down. So it flows down to us 3 kids. So we each share 1/3, 1/3, 1/3. However, God forbid one of us pass away before my parents. So let's say one of my siblings pass away before my parents. So when my parents pass away, it's going to go down to me and my surviving sibling. But according to Florida law, did that sibling that passed away before the other 2, did that sibling have children? So let's say it's my brother who has 3 children. So his share, his 1/3, is going to go down to his 3 children. So his 1/3 will be split 1/3, 1/3, 1/3. Now let's pretend that it's one of my brothers that doesn't have any children. It's passed away. So his stops with him. It can't go down. It can't flow. So it's going to have to flow sideways. So then me and my surviving sibling will split it 50-50. That's intestate. That's I die without a will. That's how the law says it. That's what's going to happen. Don't think that somebody from the state of Florida is going to come down and swoop up. I get that a lot. Oh, well, if I don't do a will, the state of Florida is going to get it. No, Ron DeSantis is not going to drive to your house and take over everything. That's not happening. There's laws to ensure that things go by the blood. The only time a little confusing is when there's no children or children that are split. Your partner has children, you have children, and then you have children together. That's a complete whoo. That's when you really, really, really need to ensure your things and stuff are in order. Also, with a will, you get to pick who is going to, how do I say, administer your will. Who is going to go to the attorney, submit the will to probate, make sure everything is divided as it should be, and make sure it closes out. As the individual, I get to choose who's going to do that. Whether it's my husband, my parents, my brother, my son, whoever it may be, that's a job that they're given. And I always advise people, don't just pick one. Because God forbid something happens to that one person. You want to make sure, I at least make sure my people are 3 deep. If the first one can't do it, is unwilling or unable, the second. If the second is unwilling or unable, then the third. God forbid the third is unwilling or unable, somebody's going to petition to be the administrator. So that's what we call a personal representative. So always make sure that you have those named in your will. So what I said is, the will, like I said, the executor has to make sure the will closes. A will has to close. It can't go on and on and on. You can't put in a will, well, I want my grandchildren to have the money, but I only want them to have it, okay, when they graduate from high school. Then they're going to get a certain amount when they graduate from college. Then they're going to get a certain amount when they buy a home. Then they're going to get a certain amount when they got married. No, a will does this. Here you go, things and stuff. You get them. Now we're closing out. We're not distributing as you see fit. We're doing it whatever you say, and then it's done. If you don't want that, if you want it, like I said, well, I want it when they graduate from high school. I want it when they get married. I want it when they graduate from college. I want them to get bits and pieces. I don't want them to get everything at once. Then you need to do something called a trust. A trust. Like I trust you, Trust. You want to do a trust, just like the overlay says. I like to spell, it helps people out. Anyway, a trust document dictates how you want things distributed and if they're going to be distributed over a certain amount of time, meaning over several years or even several months. Things need to be spelled out in a trust. And 9 times out of 10, you don't have to probate a trust. A will, you have to go through probate. You have to go through that court proceeding. And that can take a long time. A trust says, I'm the trustee. I've created a trust. The Laura Sterling Revocable Trust. As long as I'm alive and as long as I'm able, I can do whatever I want with that trust. The minute I die or the minute I become incapacitated by a court of law, now it's dictated by the terms of the trust. Nobody can take out or put in without it being dictated by the trust. So I'm the trustee, I'm the grantor, I can do what I want. When something happens to me, my successor trustee now takes over and they're doling out per the instructions on the trust. Again, the trust is if you want something to go out over time. I don't want them to get it all at once. I want it allocated for certain milestones in their life or maybe certain ages or whatever it may be. I once had a woman that her husband passed away and he had a few $1 million in the bank. I was pretty impressed. And she was probably in her 60s, late 60s, and she had a child that was in their early 40s. And if she were to pass, because she got everything as a wife, and she didn't want, if she were to pass away, for it to go to her daughter right away. She wanted it to go over time. So I had to do a trust. But then I was like scratching my head and I said to her, you know, your daughter's like 42 years old. Like, how do you plan on doing this? But that's what she wanted. I just asked the question. She still wanted it. I did it for her. It was fabulous. So she said she didn't want her daughter to not work, to think that, oh, well, I have this money coming to me, so I'm just going to do nothing. She didn't want that. She wanted it staggered. I said, smart thinking, smart woman. Anyway, so a trust is just that. It's doling out the money on certain occasions, certain period of time, whatever you want. Also, I recommend a trust when there's more than one piece of property. Because here in Florida, your homestead is protected by the homestead law. And so it automatically will pass. However, if you have multiple homes, properties, I have a beach house, I have a condo, I have this, I have that, then those things are not protected. They're not protected homestead. Your creditors can go after them. So I always say, hey, if you have more than one property, let's do a trust. Melissa, look at you. Oh, you look so beautiful. Thank you for joining. Good afternoon. How many people can I name in my will to be personal representative? Good question, Melissa. First of all, I know the amount you should not name in your will to be a personal representative is this many. Because, Melissa, what if you name me as your personal representative and something happens to me? Now what? Now you either run into an attorney paying money to do a codicil. A codicil is an amendment to a will just for a certain part, where you're having to name another personal representative, or you forget about it, you die, and now all of a sudden you have a will with no personal representative. And who knows who's going to be coming out of the woodwork to request to be your personal representative. You want that choice while you're alive. You don't want some court or somebody else to decide that after you've passed away. So I always tell my clients, like I said, safely 3 people I name, but you can go at it. I have people with multiple children. They don't want one child to feel left out. So they got to name like 6 children, oh, of this one and this one. That's perfectly fine. That's up to you, whatever you want to do. I would do more than 1, but at least 3, and then however you feel comfortable. But excellent question, Melissa. There's no law or anything in the statutes that say you're limited on the amount of personal representatives. And Melissa, that brings up a good question, a good thought. You can even do co-personal representatives where they both can work together, but you want to make sure that maybe they can work kind of independently of each other. Otherwise, you're marked with having these 2 kind of joined at the hip. But again, that's up to you. There's no real restriction or anything on the law against it. So excellent question. You're welcome, Melissa. All those S's, I love it. So that's a trust. Oh, hello, Flor. Hi, what is the difference between a will and a living will? Good little segue there, Flor. I like your question. I was just going to go into it. A living will. What is a living will? When I talk, I always say, okay, there's a will and a living will. Does anybody know the difference? And they always raise their hand. Well, one is for your stuff and one is for like your cat. I always get all these different responses. Think of it, a living will is while you're alive. It addresses while you're alive, and it addresses your living body. So I say wills, an actual will is with your things and stuff. A living will is your body. What are you going to do with your body if there is 3 criteria for a living will to come into place? You are an end stage condition. You have a terminal condition with no hope of recovery, and it's an end stage. It's an end stage. You are unable to make decisions on your own. So you're unable to make decisions on your own, end stage, and it's a terminal condition. That's when the living will. And you have to have 2 physicians, at least here in Florida, 2 physicians certify you have those 3 elements, and then your living will kicks in. Most people put in their living will that they just want to be kept comfortable. I just want to be kept comfortable. I don't want to be hooked up to machines to keep me going. I don't want to be hooked up to a vent, a trach, a respirator, a heart machine, whatever it is. I don't want to be fed through a tube through my stomach or through my nose. I just want to be comfortable. I just want to have pain medication so that I'm free of pain, I'm peaceful, and I can go when I feel like it. So that's what a living will is. It has to do with while you're living. And then a will has to do with your things and stuff. A lot of people come to me for estate planning. I leave the living will for last because it's always a sensitive subject to people to kind of talk about, okay, when you're in your dying process, what do you want done? People get a little, they want to kind of stop. And 2, what I always tell them, you don't have to do it now. I'm going to be here for you whenever you're ready. But the most important thing is if when you're going to do a living will, when you've made that decision, is to talk to your family members and make sure they understand your wishes and that they will follow your wishes. Because like I told you before, I worked 10 years in nursing homes. I'm a licensed social worker. I work nursing homes, and I've seen some crazy stuff go down over people's living wills. I see families like totally disregard them, don't even pay attention to them, destroy them, try to make them null and void, make the poor little person who is obviously in an end stage condition, not able to make decisions, and in a terminal condition. They don't need that tube feeder. They don't need that. Of course, that's my belief, and everybody else has their own belief. But understanding that if I make a living will, that's my wishes. I'm wanting whoever I appoint to make those decisions for me when I'm unable, to know that it's a decision I've made and to honor that decision. And it's not a decision they're making. So I always tell families, talk to your loved ones when you do the living will. When you decide to do it, make sure you're all on board and make sure you're all on the same page. Anyway, that's just a little snippet of what estate planning is. My next live, which is October 22nd at 2 p.m., I'm going to go over the other half of estate planning: power of attorney, healthcare surrogate, healthcare proxy. And I'm going to dibble a little bit in guardianship, but not too much because we have a whole month dedicated to guardianship. So please remember, if you're living here in Florida, I'm more than happy. I'm more than willing to sit down and talk with you. And I go over everything when I go over estate planning, your bank accounts, ways you can, wink, wink, avoid probate, all that kind of stuff. And that's what I'm here for. Like I said, I worked in nursing homes for many years. So talking about this is like talking about air. I can talk about it all day long. So please stay tuned for October 22nd at 2 p.m. And for my fellow Floridians, stay safe, and we're here for you. Take care.